The simple answer is that a president can be impeached without a statutory crime being committed. That was the position, and the question was rejected in President Nixon's case and rejected again in President Clinton's case. It should be rejected here in President Trump's case. The great preponderance of legal authority confirms that impeachable offenses of legal authority confirms that it is not defined in criminal conduct. This authority includes nearly every legal scholar to have studied the issue, multiple Supreme Court justices who addressed it in public remarks, and prior impeachments in the House. This conclusion follows that constitutional history, text, and structure, and reflects the absurdities and practical difficulties that would result were the impeachment power confined to indictable crimes. As slide 35 shows, first, the plain text of the Constitution does not require that an offense be a crime in order for it to be impeachable. Alexander Hamilton explained that impeachable offenses, high crimes, and misdemeanors are defined fundamentally by the abuse or violation of some public trust. Some public trust. They are political as they relate chiefly to injuries done immediately to the society itself. Offenses against the Constitution are different than offenses against the criminal code. Some crimes, like jaywalking, are not impeachable, and some forms of misconduct often offend both offend the Constitution and the criminal law. Impeachment and criminality must therefore be assessed separately, even though the President's commission of indictable crimes may further support a case of impeachment and removal.
Hey, NBC News viewers, thanks for checking out our YouTube channel. Subscribe by clicking on that button down here and click on any of the videos over here to watch the latest interviews, show highlights, and digital exclusives. Thanks for watching.